Opportunity to address this August gathering. It's a fantastic opportunity to engage with such an enlightened audience in the backdrop of this judgment. I was given 15 minutes in Sabarimala and I wanted to finish presenting that case in 15 minutes. Now I have to cover 3 cases in 15 minutes and I'll do it. So let me just give a broad overview of what are the issues in play here. So just keep pace with me for a moment. I'll try to keep this as simple as possible. But this discussion is impossible without any reference to the relevant legal provisions. So let me just introduce those provisions in a jiffy and then proceed to explain how it works together, how these provisions work together, and how do you mix law, philosophy, culture, and religion. Just hold on for a moment. So there are 3 issues here. When a community's right to cultural freedom conflicts with values of animal welfare, issue number 1. So let's give this a peg. Largely, this is about Jallikattu. Let's assume this is the case. When people's right to sexual freedom conflicts with notions of morality, section 377. When the fundamental rights of a community of devotees and their religious beliefs and practices comes into conflict with fundamental right to gender equality, Haji Ali first and Sabarimala later. So that's how I would go about it. Okay? Now, let's ask ourselves, what are the provisions in question that typically play here? Article 14. Right to equality. Article 15, discrimination based on gender and access based on gender. Article 17, that relates to untouchability. Article 19 as well, because that's not being discussed. One issue that should have been included here is because the Diwali firecracker ban also has a relevant bearing here. So that's a relevant issue. So Article 19, because there are manufacturers who have rights under that. Then you have rights under Article 21, right to life, of course, but that's not largely a question in let's say, issues 2 and 3. Then you have Articles 25 and 26. Keep aside all these provisions for a moment and only focus on Articles 25 and 26 because these are the central provisions when it comes to the discussion with respect to issue number 3, Sabarimala. I'll start from there. And also perhaps, no, I'll go with issue number 3. Article 25. Gives Sai Deepak as an individual the right to practice and profess his faith. But that is not an absolute right. It comes with its own riders. It starts with what we lawyers call the contingent clause, subject to. Subject to other parts of this, other provisions of this particular part. And therefore, what is the other provision that Article 25(1) is subject to? Article 26. And what is Article 26? That relates to institutional rights. So the right of an individual to practice, profess his faith and his conscience is subject to other parts of the other provisions of the particular part, which includes the rights of the institution. Why is this important? Now, I am not a scholar of comparative history. I would consider myself as someone who has perhaps an interest in constitution. I am not sure of the aptitude or the flair for it, but certainly an interest, more than a passing interest. So I'm not sure if there are provisions which are comparable to Article 26 and 25 or the collective, let's say, message it conveys in other constitutions. But the reason why they exist insofar as India is concerned is because it recognizes individual path to that divine. It recognizes the right to practice and profess that particular path. It recognizes the diversity of this country and it removes the jaundiced lens of the Britisher and then says, I'll wear the Indian lens again and ask myself if this is discrimination or diversity. It does so. So the question is between, is it Navanirman or Punarnirman? Do you want to destroy everything that is old and build something on the edifice or the debris of the past? Or do you at least want to pick something from the past and remove and weed out what is not desirable? And continue to hold on to those aspects of the past. Because a society that does not believe in its past or does not have a pride in its past has no future. I don't know who said this, I am saying this. So, as far as I'm concerned, it is important to understand and respect this. Kadavul ellam onnu. I don't know who knows Tamil or who doesn't know. I'm simply saying God is one. Then why do you need religions? Why do you need sects? Why do you need subsects? Vadagalai, Tengalai, Bracharanam, Discharanam and all that, it will go on forever. Why? Because at the end of the day, this country's propensity for engineering and innovation in religion is something that we have to recognize. And therefore, every expression of that particular innovation needs to have a certain protection. And that protection comes under Article 26, which is the rights of a religious denomination and institutions run by religious denomination in matters of religion and in matters of ownership of their properties. Therefore, it is every path that leads to the divine which needs to be protected. The manner in which that path is maintained, the manner in which you choose to approach the divine is to be maintained, and that is to be preserved and protected. So each time you've had a debate on these issues, it's almost couched in a manner where it is given the impression that only one side enjoys fundamental rights and the other side's rights are not fundamental. So I'm so sorry. You're talking of a balancing act with respect to two sets of fundamental rights here. Let's be clear about it. So if these are two sets of fundamental rights, the court is faced with this tricky question of which should prevail over what, under what circumstances, under what conditions. And you need to lay down the test. Because it is possible for the court, which it has done so in 493 pages, whereas the same judgment was given in 67 pages by the revision bench of the Delhi High Court, that you have flights of fancy and flights of philosophy where your jurisprudence is meandering at 60,000 feet. But for the common man, for the practitioner, what he asks for, what he expects, is what is that Lakshman Rekha that I'm not supposed to cross? What is the thin red line that separates the legal from the illegal, from the constitutionally moral to the constitutionally immoral? Therefore, every proposition needs to be reduced to the form of an applicable test, which is broad enough, which is flexible enough for future application, regardless of the situation that is presented before it. And assume that it is presented with a situation which the test cannot satisfy, you need to invent a new test. What is the test which applies to some of these cases, or broadly the conspectus of the topic here, is the essential practices test. The essential and integral practices test. What is the test? What is that esoteric test? Simple. It's as simple as this. When the state has the power to protect the individual's rights under Article 25(1), and it also has the right to protect, or rather the power and the duty to protect the institution's rights under Article 26. If the institution chooses to impose itself on the individual, causing discrimination, how do I prevent that? What is the institutional pushback? Therefore, some kind of levers are necessary. Most importantly, since you're talking of the Constitution, you also have to recognize that the judiciary is not the whole and soul of the Constitution. Because at the end of the day, doctrine of separation of powers is a basic part of the structure of the Constitution. Therefore, there are some things which the judiciary can interfere with, and there are some things that the legislature needs to interfere with. That is the Lakshman Rekha that the judiciary needs to respect. And I've said so openly, so I don't have a problem. I've said the same thing in court. Contempt of court cannot apply. So the point is, I said this in as many words in the Sabarimala case, that there are certain provisions which you cannot invoke. It is for the legislature to invoke, subject to consultation with the community, subject to reform and the clamor for reform coming from within the community. Therefore, unfortunately, you have to suffer a bit more of legal discussion here, which is the distinction between Article 25(1) and 25(2). 25(2) as a provision speaks of the power of the legislature to reform certain aspects of all religious institutions in one instance and only Hindu religious institutions in another instance. That is only the power of the legislature. That means Article 25(2) cannot be used as a reformative lever by the judiciary to reform any aspect of the institution under 26. That is for the state to do. Why is that power given to the state? Because they recognize that this requires a mandate from the constituents, from the republic, from the sovereign, which is the people, the electorate. And when that particular opinion gains a certain amount of traction, a certain amount of critical mass, then it translates to pressure on the executive to set the ball rolling in the legislature. Therefore, it's not for the judiciary to find an exit option or a backdoor in 25(2). Its options are only under 25(1). Let's be clear about this. Now, be it 25(1) or 25(2), this essential religious practices test was formulated in the backdrop of 25(2) largely in the context of the lovely, beloved Hindu religious and charitable endowments legislations which govern our temples. So, as a consequence of a discussion on 25(2)(b) and 26(b), the court was asking itself this simple question: when the executive or the legislature chooses to interfere with the running of a religious institution, to what extent can it interfere? To what extent can it encroach upon those rights? So it says, you can only interfere with secular aspects, you shall not interfere with religious aspects. That difference was drawn. Therefore, what is secular and what is religious was carved out largely. Plus, even what is religious would mean essential religious practices. So the question that you have to ask yourself is, if this is the test that is carved out by the Supreme Court to strike a balance between the rights of the individual and the rights of the institution insofar as 25(2) is concerned, surely the same logic can apply with respect to 25(1) as well. Because what does this provision or interplay largely mean? The nation state as a concept is a relatively new concept. It's a relatively recent concept. But faith and religion have existed for millennia. So when nation state as a concept comes about and constitutional democracy comes about, you need some kind of a compromise that is worked out between someone who's been around for 10,000 years or 7,000 years and someone who's arrived in the last 1,000 years or 2,000 years. And that particular compromise is worked out in terms of this essential practices test, which is to say the state is basically saying, I shall not touch those aspects of your practices which are essential and integral to your character, to your schema, to your makeup, to your identity. Because if I take it out, I have reformed you, but I've also reformed you out of your identity. This is the test. So that is the test that is also to be applied when it comes to 25(1). So what is the consequence of this? Constitutional morality does not mean pitting the constitution against faith. It means locating the place of religion within the constitution, and not to say that the religion or let's say the faith systems are completely alien and it is for constitution to sit and reform religion. At least as far as the Indian constitution is concerned, that kind of an interpretation, according to me, still is wearing the lens of Thomas Barrington Macaulay. So as far as I'm concerned, so I'll give you why I make this point. When it comes to application of certain principles of equity or common law or torts, Indian courts have taken the position that you may import a certain principle, but its application shall be Indian. But somehow when it comes to constitution, we are open to importing everything from abroad and imposing as is where is toto in entirety without any change whatsoever. That makes really no sense to me. You want to apply those principles. I'm not saying do not be open to any learning from outside. Do not be open to anything good that comes from outside. But when you apply it to India, kindly leave aside the prejudice. Oh, subalterns. You need to leave that out of the equation and ask yourself, do I know what I'm talking about for me to be in a position to judge and then say this needs reform? That is precisely why, as part of the essential practices test, what the court calls for is ask yourself the basis of a certain religious practice. Ask yourself what is the basis in the scripture. But what do you do with a faith system which believes in both Shruti and Smriti and not necessarily a codified book which is equal for everyone and which applies to everyone? That is why customs become important. That is why tradition becomes important. Therefore, documentary evidence with respect to the existence of a custom becomes important, because I can't have Ayyappa saying, no, not possible. In our case, we did that as well. Which is, we showed the actual Sthala Purana, which is the Bhutanatha Upakhyanam. We didn't cook up anything in the air. So the point I'm trying to make is this. In order for you to say that something is discriminatory, in order for you to say that something at the outset has its object as exclusion, you need to understand the practice in the first place. I'm not saying necessarily accept it and embrace it, but at least understand it, comprehend it, understand its spirit before you come to a conclusion that this is discrimination. Therefore, what I said in the Supreme Court is what I shall continue to say here, that the case is fundamentally a question of the petitioners being unable to strike a distinction between two Ds, diversity and discrimination. Because of all the people, it was the lady member of the bench who asked this fantastic question. Are you saying there are no examples in this country where there are restrictions that are put on men? This question came from the lady member. And when they said, yes, of course, there are such examples, the question that she put was, so what is your position going to be with respect to entry of men into those institutions? Oh, men must be allowed. So you don't see any distinction between diversity and discrimination. And according to you, all exclusion is discrimination. And according to you, I need to cut every head to fit the hat of modernism, liberalism, secularism, or constitutionalism. In the process, killing the spirit and the mandate of constitutional morality. Thank you.